Hello, my name is Jennifer George, and I'm an attorney at Isaac Brandt Ledman & Teeter in Columbus, Ohio. And one of the areas of practice that we excel at here at Isaac Brandt is in the area of employment law, where we represent employers in litigation, all the way to interact with employers in an ongoing counseling relationship to provide input on policies and procedures, training matters, and other such things. And one of the areas of interest that I thought may be out there for employers today is the amendment to the American with Disabilities Act, otherwise known as the ADAAA. And these amendments came in the form of what was called the American with Disabilities Act Amendments Act, which took effect on January 1, 2009. And to appreciate the amendment, it helps to first start to talk about what does an employee actually have to prove to claim or to be successful to say that an employer discriminated against him or her on the basis of their disability. And for that, there is 4 things. First, the employee has to show that they are in fact disabled according to the definition under the law. Second, the employee has to show that he or she truly is qualified to perform all the duties of the job that are required of them. Third, the employee needs to show that they suffered an adverse employment reaction, anywhere from a reduction in pay to termination. And lastly, they need to show that you, the employer, took this action against them for an improper, unlawful reason, and that perhaps the reason you're alleging is what they call pretext or a cover-up reason or excuse for in fact discriminating on the basis of the employee's disability. So what did the amendment do? What the amendment did was it affected that first thing that we talked about, which is for the employee to be able to show that they're in fact disabled. And the amendment changed it by saying perhaps the employee does not need to be affected in so many different ways in their life. Perhaps the employee should be taken into consideration without the benefit of their medication in what is called their uncorrected state. Perhaps the substantially limiting effect of the disability or alleged physical condition does not need to be as severe as it once had to be. And perhaps the employee is simply misperceived as having a disability, and this then has an effect on the employee's status of their job. All of these things work to lower the bar, to make it a little bit easier for an employee to show that they're in fact disabled. So what does this show or teach you as the employer on a practical basis? I think there are 2 valuable lessons to be learned. First, make sure your policies and procedures, which include your job descriptions, are updated. Does a job description have everything that truly an employee is required and needed to do on a daily basis? And second, reasonable accommodations, which is a change in duties as a result of a person's physical condition. If you receive them, consider them cautiously, or perhaps if you have information that should lead you to offer a reasonable accommodation, also consider such information cautiously. Isaac Brandt has a presence on the web, or we can be reached at 614-221-2121 if you want to discuss this or you have any other matters that we can help you on. Thank you.